أتوجه بسؤالي لجمعية التحكيم الأمريكية وذراعها الدولي مركز تسوية المنازعات الدولية AAA ICDR، الشركاء الاستراتيجيين للمركز، ممثلين اليوم في الرئيس التنفيذي لمركز تسوية المنازعات السيد إيريك. إن أردت أن أسأله باختصار شديد حول كيف هي العلاقة بين جمعية التحكيم الأمريكية والمركز السعودي للتحكيم التجاري، كيف يقيم هذه العلاقة وكيف يقيم صناعة التحكيم المؤسسي في المنطقة بشكل عام.
Thank you very much. Good morning, and thank you, Your Highnesses and Your Excellencies, for having the ICDR as a part of today's event. And of course, a thank you to all of the SCCA staff who have been really wonderful to work with. In terms of where we stand with this relationship and partnership, I think it's interesting to look at how it all evolved and what was unique about the SCCA's approach to establishing an international arbitration center. And at this particular point in time, there are many organizations and many jurisdictions that are looking to establish dispute resolution centers to handle international, commercial, or investment disputes. But there was something unique about the way that the SCCA approached the establishment of a center, and also unique in the way that they approached the AAA and ICDR. So I would characterize that as a group of people that were driven. I think one of the most basic and important characteristics of an organization that would like to be a leading arbitration provider is to have a deep and somewhat passionate understanding of the process. You need to really be advocates and look for and look to international arbitration as a way of effectively resolving disputes in a way that is completely neutral, impartial, and does not bind the parties to an allegiance with a particular set of laws or jurisdiction, except to the extent that they agree upon that. I think something else that was unique is a concept that's been discussed by many of the other panelists, and that's this: it's a partnership that needs to exist between the judiciary and the arbitration process. They're not completely separate. Courts need to respect agreements to arbitrate, and they need to respect arbitration awards according to the deferential standard that's been afforded. But there needs to exist that partnership. And it was very clear that there was a desire to establish that in a way that drew that appropriate balance. So two aspects. One is the establishment of a center with people that were committed, driven, energetic, and passionate about the process, and an understanding of the need for courts to recognize the appropriate relationship between the arbitration process and the courts, and a deference to the arbitration process. That is what makes the process work. There are other aspects that were also apparent as we worked with the SCCA, including an immediate recognition of the need for education, educating the legal community, the business community, governmental entities. That is a tremendous effort, and it's ongoing, and it will need to take place for the entirety of any institution's life. Obviously, identifying a roster of arbitrators that parties are going to find acceptable to international disputes. It needs, again, to have the right balance of people that will understand and have the expertise to decide subject matter that may be unique to the dispute, but also a recognition that parties want arbitrators from parts of the world that aren't necessarily tied to a particular jurisdiction. Again, I spoke about the training that needs to take place. That needs to take place throughout both the institution and also the community at large. Again, I would say the ICDR is contacted on a regular basis by organizations around the world that want to establish centers. I will leave my comment with one other characteristic which I think is so critical, and that's patience. It takes time to develop a center, and first you have to go through all the steps that have been discussed about making sure the laws are appropriate, education is appropriate, an institution that's credible, independent, neutral. But it takes time for the parties to recognize that, to incorporate an arbitration clause into their contract that specifies a particular provider. And then you have to wait for a dispute to arise out of those contracts. So it can take quite a bit of time, and it takes a lot of patience and perseverance. But we've seen quite a bit of that in our interaction with the SCCA.
لشركائنا في المركز تسوية المنازعات الدولية حول أبرز المبادرات أو القائمة والشراكة مع المركز بين جمعية التحكيم الأمريكية وذراعها الدولي مركز تسوية المنازعات وبين المركز السعودي للتحكيم التجاري، بالأخص المبادرات القائمة وبعض آفاق لتطوير هذه الشراكة في المستقبل القريب.
Well, I've described a little bit already how the relationship came to be. Once we did enter into really this agreement, this partnership with the SCCA, there was quite a bit of activity that took place almost immediately. So the discussions took place in 2015 approximately, but in 2016 is when we really started to work with each other. And that started with simply having visits with quite a number of the SCCA staff. The then newly appointed CEO and COO came to New York and met with, obviously, the International Center staff. And that was substantive. These were discussions about how you actually administer cases. And as cases can proceed in arbitration, there are many contingencies, there's many changes, there's a roadmap that's provided for an arbitration process to proceed or mediation, but there are all sorts of variations in terms of arbitrator selection, variations in terms of what happens when somebody's unable to serve, or they've got conflicts of interest, or how you handle financial transactions. There's quite a bit of knowledge to understand there. But another important part of running an institution is actually running it operationally. And many people don't think of this aspect of an institution, but it is critical. So having an IS department to handle technology, particularly at a time where cybersecurity is so important, that's a large component. There will be computers involved in case management. And so the executives from the SCCC met with our Chief Information Officer. They met with the legal department. I'm also general counsel, and there are legal issues that arise, just like any other organization, just like any other entity. There are going to be matters that arise, litigation itself, contracts, employees, things of that sort. Finance is also, I've just touched on that, but a very important part of the case management process. The case managers usually are holding on to a certain amount of money. They have to decide when to distribute it to arbitrators, when to hold on to it, and how to handle those issues. Finances are important. They must be tracked. They must be handled with particular preciseness. So these initial meetings were very important in giving a very holistic exposure to what an institution does and what the different aspects of the employees that are involved in an institution, what roles they play. So that happened pretty early in the relationship. But it has also continued at a regular pace. 3 case counsel came to New York that same year. They came for 4 weeks. Obviously their focus was much more on the case management process, but they sat with our own case counsel in New York and actually worked through cases from beginning to end to have an understanding about what the process looked like and what an appropriate role for a case manager is. An important part of an institution is understanding where the dividing lines are between institutional authority and arbitrator authority or courts authority. And it's important that we recognize our roles as an administrative body and that we leave the merits up to arbitrators or to other decision makers. But there are issues that we need to assert ourselves in as well, and so an understanding of that was shared. We were also able to share how we work with the legal, business, and judiciary, how we interact with them in New York, either through conferences, meetings, presentations, and the like. Every one of these needs to be done in a way that's appropriate within a particular area, according to custom and practice. But in terms of how we do that in New York, we were able to share that as well. And those experiences are particularly important when an institution is trying to get the word out and share knowledge that it's credible and that it exists. These experiences, these types of exchanges with staff, with executives, I was very happy Dr. Hamed was over in New York just a number of months ago as he was getting comfortable in his new CEO role. And again, we were able to have him meet with just a large number of the AAA ICDR's executives to understand how governance works, how management works at our end, so they could take those experiences, to the extent they were relevant, back here and incorporate them in a way that would be suitable. We continue to have case counsel visit us in New York with the same purpose of meeting with staff, understanding how we handle an administration process, the letters we write, how we communicate, how we establish neutrality, and again, how we draw the appropriate role for an institution. And then, as I say, up until recently, very recently, we've had quite a number of visits. Again, in talking about the staff that we've been exposed to, there's tremendous devotion, energy, interest, a warmness, a willing to engage, and those are all critical to success.
Thank you, Eric.